Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. I'm your host, Anant. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law. And casual listeners seeing these issues in front-page headlines and trying to better understand them. Each episode is presented by one of the specialty committees within the section. This episode, produced and co-hosted by the Federal Civil Enforcement Committee of the Antitrust Law Section. In today's episode, we break down the closing arguments in the Google search case. Google, a tech company whose very name has become a verb synonymous with online search. At the tail end of the Trump administration in 2020, the Department of Justice's Antitrust Division filed its biggest monopolization case in the tech sector since the landmark Microsoft case some 20 years earlier. The 2020 case, US v. Google, was joined by 35 states and alleged that Google had used anti-competitive practices to maintain a monopoly in search and search advertising. And for our listeners, because all of the tech antitrust cases can get confusing, I want to clarify that this case preceded and is separate from the 2023 US v. Google case filed last year in the Eastern District of Virginia, which alleged monopolization in the digital advertising market. The complaint in the 2020 case alleged that Google has become the dominant search engine in the US, not because it is the best product, but by using a variety of illegal practices to maintain its dominance. These practices included paying to be the default search engine on browsers such as Apple's Safari and Mozilla's Firefox, and requiring pre-installation as part of a suite of Google apps on handsets using Google's Android operating system, the number 2 mobile operating system in the US behind Apple's iOS. The alleged harms were that competing search engines such as DuckDuckGo, Yahoo, and Bing were foreclosed from reaching distribution and scale, that search quality on parameters such as data privacy have decreased for consumers, and advertising buyers lacking a competitive market are paying higher prices. After a lengthy pretrial period, the case went to trial 3 years later in November 2023 before Judge Amit Mehta, the District Court of the District of Columbia, an Obama appointee. Closing arguments were held on May 2nd and 3rd of 2024. In today's episode, we're going to break down those closing arguments, 3 of the most distinguished antitrust trial attorneys in the country. We're going to hear from our experts on what worked for the prosecution and defense, what didn't, and what our panelists might have done differently. We're also going to share any insights these arguments gave us into the government's other pending cases against big tech companies like Amazon and Apple, as well as the second case against Google involving ad tech. Joining me today as my co-host is Christopher Graham, an antitrust attorney at the law firm Sullivan and Cromwell. Welcome, Chris.
Thanks, Anant. Glad to be here.
Who do we have on the show today?
Our first guest is Tara Reinhart. Tara is a partner and head of the Antitrust Competition Group and Skadden's Washington office. Prior to joining Skadden, Tara served as the chief trial counsel for the FTC's Bureau of Competition. While there, she led the trial team in the successful challenge to Staples' proposed acquisition of Office Depot. Our second guest is Kalpana Srinivasan. Kalpana is the managing partner of Susman Godfrey. Among her many recognitions, she's been repeatedly recognized as one of the top 500 lawyers in America by Law Dragon.
Kalpana is also my college classmate.
Our third guest is Dan McCuaig. Dan is a partner in Cohen Milstein's antitrust practice. Prior to joining Cohen Milstein, Dan was a trial attorney with the DOJ's Antitrust Division, where his work included overseeing the government's investigation in the ebooks case.
Judge Mehta organized the closing arguments into 3 main issues: market definition of market power, anti-competitive effects, and pro-competitive benefits and balancing. He also raised the issue of sanctions. We're going to go through each of those to hear our panelists' impressions. But first, lead question, panelists, the closing arguments. Overall impressions? What went well for Google or the DOJ? What didn't go well?
Well, thank you for having me on, and thank you, Chris, for asking me to do this as well. I'm Tara Reinhart. First of all, let me say, I thought the Judge Mehta was the star of the show. He was so well prepared, had the detailed evidence at his fingertips, kept quoting cases to draw out either side in his questions. My impression is both sides performed well, but more things did not go well for DOJ than did not go well for Google. And I'm putting that in the negative intentionally. DOJ really had a problem giving the judge what the judge was asking for. The judge was asking for evidence, support for the notion that Google had more share than it should, that Google was pricing higher than it should, that Google was doing things to keep people out that it shouldn't be doing. And the DOJ, this is just an overall impression, but the DOJ consistently stuck to its view that it had very little that it had to prove. Basically, market shares and exclusivity and not much more. And several times said that to the judge, and several times said to the judge, you're putting a burden on me that I don't have. And so as a result, the judge is left with a record that could have been a good record for either side or both sides. That is, ordinary course documents can be very strong evidence. Some witnesses that are anecdotal, that could also be strong evidence. But the judge was really looking for something more, analysis, economic analysis that would give him the answers, because what happened with the evidence as it came in is Google did a good job of disputing what the government said the evidence said. And so I think the judge is now in a hard spot as he's having to decide some pretty difficult issues. And I do think the DOJ could have given him more and just didn't do the economic analysis that would have given him more.
I'll chime in next. Thanks, Anant, for having us and giving us the opportunity to comment on this obviously major milestone case. I think that it is clear that to position itself or to try to frame how these cases may be decided, especially involving technology, Google had to really rely on drawing from analogies or using other areas to describe competition. And I know we're going to talk about this more, but certainly they can't really take on the fact that they are their market power for search. And so they have to sort of redirect and reframe the question to be about things like these verticals and the ability to find competition in these other pockets. And I think that, they certainly gave the court and listeners a lot to think about in terms of whether that's a fair way to analyze competition, notwithstanding what the law says. But I do think it was clear that those were necessary steps for Google to be able to try to put on a front for what is the competitive environment today. And so I think that was a challenge for them in the sense that it's a little bit of a concession that they need to reframe or redescribe what the market is or who their competitors are in order to do that. And probably also a broader recognition that may be an issue that arises in a number of these cases when we're talking about technology like search, like free platforms, and looking at and really figuring out what the competitive market is and what the competitive harm might be.
Thank you, Anant and Chris, for having me on. And I certainly agree with Tara that Judge Mehta is exactly the judge you want when you have a good case. It just comes across as ridiculously smart and prepared at all times. And I agree with Kalpana that the parties seem to be trying slightly different cases throughout the closing arguments. And at the end of the day, Judge Mehta will have to decide whose case he thinks is the right case to decide and how that case should be decided. I think the DOJ did well on market definition and then following that on Google's monopoly power in both general search and search advertising, right? The areas that Kalpana, I think, correctly noted that Google was trying to mix the issue a little bit. But then as the analysis moved forward and into questions of foreclosure, I think Google did a lot better. Holding aside mobile for a second and just focusing on the bigger search markets, competition for the contract is a real thing. Competition for the contract to be a default search provider matters, right? And in most circumstances, for Section 2 purposes, you're not actually foreclosed from commerce that flows through any contract that you can compete for. One theme that I think Google presented nicely throughout closing arguments was the contrast of this case to Microsoft, right? And presenting this case as a bigger reach for the government than Microsoft was, primarily because in Microsoft, the monopolist was forcing personal computer makers to take an inferior browser that they didn't necessarily want, whereas Google wins its default search placements by having a browser that the third parties think is the best browser and offers the best monetization. So I thought the DOJ set the table well, but then, like Tara said, had a hard time bringing it home. And Google tried to duck and weave a little bit, not that effectively, I didn't think, but then was able to stop the government at the door in most cases. I'm sure we'll circle back to the Android situation.
This case was referred to in the New York Times as the antitrust trial of the century. Do you think that's a fair characterization?
I do, in the sense that we haven't had, really since Microsoft, too many industry-defining cases in the Section 2 landscape that of this nature. And also because everybody is looking to see how the application of the law will evolve as we are talking about these new technology markets. And I do think a lot of the issues, including what kind of proof you can put on a foreclosure and what you can look at in the competitive market, is different given the nature of what we're talking about. And so I think for that reason, and obviously there are a slew of other tech-related antitrust cases that the government has brought and private actors are pursuing, they're coming on the heels of this, and they're looking very carefully at what the legal standards are going to be. And is there going to be a reinterpretation of how the Sherman Act works here? So I think it's a very critical, seminal case that is going to influence the direction of how competitive activity can be pursued against these types of companies. And I don't think we have seen the likes of that since Microsoft.
I agree with everything, Kalpana, everything you said. One more point, though. Everyone's looking to this case because there are so many companies like Google that have grown to become the best, and by becoming the best, they're one of the only that does whatever they do. And we're all looking to see how the courts are going to work with the allegation that even though they became the best lawfully, now all of a sudden what they're doing is illegal. And I do think that's another contrast from the Microsoft case, and Google pointed this out. The difference between the two is, Microsoft became what it was lawfully, but then it engaged in new behavior that was exclusionary. And here, one could say based on the evidence, Google has just continued to be Google, and they continue to be the best, and they shouldn't have to give up their business just to give someone else another chance. Again, I'm only commenting on that because I think a lot of us are watching to see how Judge Meagher is going to pivot from having become big. Are you allowed to continue to be big?
What about ebooks? No, seriously, I think those are all great points. If I were going to take the devil's advocate side, just of the question of is this the antitrust trial of the century, I'd point out that the National Association of Realtors case is literally dropping transaction costs while we record this podcast on the biggest purchase that most of us make in our lifetimes, and that even this US v. Google case, I think ultimately is probably less important than the ad tech stack case. Obviously, that trial hasn't happened yet, but when it does, the major question on the table, if the DOJ is successful, and I think they have a stronger case there than they did here, to be perfectly frank. The question on the table is, can we turn back the clock and unwind a merger that happened more than a decade ago in an industry where a decade is several lifetimes? And it will be a defining question of antitrust enforcement going forward.
Before we jump into the substance of the individual arguments made during closings, just one process question. The presentation of evidence concluded in November, and then there was about a 5-month gap until closing arguments. Is that something you've seen before in your practice, or any thoughts on why the judge structured it that way?
It seemed clear to, I think, anybody listening that he had spent time going through the record to have pointed questions about issues that he wanted to know more about. And obviously the structure guided that. And so I think one can infer that he spent some of that time going through their briefing, going through the record, the extensive record that had already been accumulated, and really thinking about what he wanted to know, because I think the level of the questioning reflected that, which you may or may not see in every closing argument, but certainly in this one. And I can imagine that the judge spent a lot of time preparing to even have these parties before him and ask things that he really wanted to know the answer to, really wanted to push for the evidence on, and I think did a very strong job of really tying that to what had been presented to him.
Yeah, I've not experienced this kind of a schedule, but I think it totally makes sense here, right? This isn't a merger case. It's not a situation where time is really of the essence as far as getting out the opinion, and it is super tricky and is going to have lasting impacts. So getting it right is more important than getting it quick. And I think the end of trial, where not just the court, but the parties are drinking from a fire hose the whole time, giving everybody a chance to gather their thoughts and really approach it as best they can, makes a lot of sense.
I shouldn't speculate what a judge has been doing, but I could picture the judge or his clerks or all of them sitting down and starting to type out the major sections of an opinion, because some of it's easy, right? The principles that are widely accepted. He's got a lot of thoughts on Microsoft. There are a number of cases that he quoted in the arguments. I could see them laying that out on paper and getting to various points where they ran into trouble. Okay, I get to this point. I'm not sure about what the evidence shows, or who made the better argument, or whether the law applies one way or the other. And so I think it's possible they prepared themselves for the argument in that way, but also gave themselves a head start on the opinion, because it's a monumental task that he's got to write something, of course, knowing that whatever he puts down and whatever is published is going to be pored over, questioned, critiqued, etc.
One final note on that. I want to thank Dan for plugging a future episode of Trust and Trade that we have in pre-production on the NAR decision. But let's get right into the substance of the case. So the first issue that was discussed during closing arguments, market definition. Chris, what was at issue here?
So there are two alleged markets: general search services and search ads, with a sub-market of search ads, of text ads. Let's start with general search. The government's position is that there is a product market for general search engines that can answer any search. In the US, these are essentially Google, Bing, Yahoo, and DuckDuckGo, and would give Google a market share of around 90% by number of search queries. Google argues that the general search market also includes specialized vertical providers, or SVPs, like Expedia or Travelocity for travel, or Amazon or Walmart for shopping.
All right, I've already staked out a position that the government wins this one, but I'm happy to kick things off. Defendants always seek to broaden product markets in ways that decrease their share, and plaintiffs always try to focus as tightly as they can on just the defendants and their very closest substitutes. It's true in all advertising markets cases, and this case is no exception. Here's a place where I thought Google's approach was smart and also not engaged directly with the government's. Google's fundamental position on the market definition exercise was, look, the money here is advertising money. And that should really be driving the understanding of what the market is. And what advertisers care about is their return on investment. And they're not focused on the arbitrary lines that the government is trying to draw here. They will move money from low return on investment outlays to high return on investment outlays. And it doesn't have to be within just a search space. It doesn't have to be even within just an internet space. This is the moonshot for all potential advertising market defendants, right? That there's really a one general advertising market because nobody ever has a share that's problematic in that market. And Google took that shot. I think they should take that shot. I thought Judge Mehta was skeptical of the return on investment rules, is the one ring that rules them all approach, but I don't fault Google for taking that shot. And then by putting that out there, they also give themselves a better shot, I think, of convincing him that these verticals need to be considered, right? That then becomes the middle, the reasonable compromise position that, okay, we're not, even if you don't give us Facebook, you've got to at least give us Kayak. At the end of the day, I don't think Judge Mehta goes there, but I thought Google did the best they could with what they had.
I agree, Dan. I thought Google did a nice job of explaining, first of all, the world has changed. General search is general search, but social media provides everybody with their information, their news, and so forth. And the SVPs, they don't play every role a general search engine does, but they do enough, and it's enough to make Google pay attention and make sure it keeps its quality up and so forth. I also thought this was another example where the government shot itself in its foot a little bit and didn't have to by really doing what government and plaintiffs often do, which is to say the market shares are high, therefore we know there's a relevant market. The market shares are high, they have market power, they can keep their prices up, therefore we know that they are exercising market power in a relevant market. And the judge actually snapped at DOJ for that, saying, haven't you got it backwards? Again, this is another example of the judge really wanting evidence. The judge was wanting to talk about substitutability. And, he goes to the Cisco case and asked each side a similar question comparing to the Cisco case that he tried and decided, are the SVPs really niche players, or is there enough substitutability so that they really should be included in this market? And I don't think that the government answered that question. This is one where, again, they fell back on ordinary course documents and natural experiments and so forth. And I'm not faulting them for that. That's good evidence. It can be good evidence, but it just doesn't substitute for a bigger analysis. And the judge was begging for someone to tell him, how are all of the constituents in the market behaving? How are they reacting? Can they substitute? Can they move? And I don't think he got terribly satisfactory answers.
I think in addition to all those points, and I certainly think it was inventive and a creative way to approach it. I think the other tactical things I would highlight is that obviously it's kind of diverting the narrative away from other failed search engines or attempts by others to develop search, from the DuckDuckGo story, which has a more traditional appeal for an antitrust case to show competitors being kept out of the market, and instead invoking these very successful companies that operate in the SVP space, and as Dan said, generate lots of advertising revenue. So it sets the stage for it being very competitive and not really focusing on who has been shut out. And the other thing is that I think by talking about the vertical providers and trying to include them in the market definition, it does take away from one of the underlying questions about the role of data and Google's ability to use the broad searches to enhance its search engine and eventually make it so that others who don't have that kind of data can't effectively compete. And in some ways, by talking about travel or an Amazon that's providing other services, it distracted away from, I think, a really important question about how a entity like Google, through its dominance, is able to maintain it because of being able to develop the data that allows it to deliver certain types of searches and be considered to be preeminent in searching. But again, that's a function of also getting the right kind of data to do it. And so I think that strategically and tactically, that makes a lot of sense for Google to focus in that direction, not just for the straightforward reasons of redefining the market, but also taking away some of these issues that I think are really important questions when you're looking at an entity like Google and search.
The government for not presenting an economic analysis of market definition. Do you think the government made the right decision there?
I do. I don't disagree with Tara at all that they took some heat for it, but I think it was the right call. I don't think any economic analysis they would have put together would have been as strong or as compelling as Google's internal analyses of the 5, 10, 15% price increases that showed profitability and so were evidence of both market definition and market power. And recognize that this antitrust division would like to de-emphasize economic analysis somewhat. They went quickly in this oral argument to the brown shoe factors, and the brown shoe factors are useful and helpful in a case like this that has such strong intuition that general search is its own thing. As Anant said at the outset of the program, Google is a verb. And the government here didn't give Judge Mehta exactly what he wanted, but I think they gave him the best case that they could.
Okay, Chris, second market, search ads. What was the issue here?
Also, the market definition question is whether search ads, the ads that pop up when you run a search on Google or a specialized search provider, are their own unique market or part of a broader market of other forms of advertising.
And so panelists, again, here we have the government trying to argue a narrower market, Google trying to argue a broader market. Do you think the government's argument was persuasive? And how much does it hurt their case if Google's market definition for advertising prevails?
I didn't find Google's efforts to take an expansive view of the advertising market to be persuasive in the world that we live in today. Obviously, you can make arguments about what forms of advertising compete with the kind of advertising that is the subject of the government's action. But I just think it was detached from the real world experience that consumers have. And I think when you're doing that, when you're going there to make your argument, it really stretched the bounds of reason from the perspective of, I think, thinking of it in a practical sense and also in the true economic and legal sense. But I just think that at a certain point, we're in an environment where people have an understanding of the kind of advertising that comes with and the power and you have as a search engine to be serving up ads, and to try to expand it to other forms of advertising and say that, there's this competitive market that includes so many different kinds of forms of advertising. It did not strike me as very compelling.
I'm going to sound like a broken record here, but I think this is just one of those areas where the judge was expressing some frustration with the government again because they weren't doing the kinds of tests that one would expect you to do with economics to actually give him a good comfort level that their narrower market was the right one. He asked, shouldn't I have expected to see some regression analysis? And DOJ's answer was, well, you're just putting a burden on us that doesn't exist. And that was that. I look at Google's argument a little bit differently from Dan. I don't think it's a deflection. I think what they were trying to do is say, that this marketplace has changed. A lot has changed. And the DOJ relies on an awful lot of ordinary course documents from a long time ago. If you're looking at today's environment and where advertisers are getting the bang for their buck and where consumers are searching and becoming interested in buying and so forth, the lines have blurred. There's definitely movement. Away from general search and movement toward trying all different kinds of websites and social media. Again, talk about a one-stop shop. There are people who get everything in their lives from TikTok or Facebook. And I found that a persuasive argument. I think the judge was left with conflicting points, conflicting evidence, probably some of it persuasive on both sides, and looking for a tiebreaker and may not have gotten it.
Yeah, I'm not sure the judge ultimately is looking at the market definition questions here exactly the way either party is. I certainly agree with the points that Tara just made. He also, though, pushed back on Google's return on investment argument at one point by focusing on Google's closest general search substitute, Bing, and noting that advertisers could realistically move only so many dollars to Bing regardless of the return on investment they realize there, because Bing's share of search is just so small, right? So even where Google is trying to kind of blow things way out with this ROI argument, the judge, I don't think he's totally buying it. I mean, I expect him to come out and basically go with the government's markets, but I'll certainly be curious. I mean, it's usually a case dispositive question.
Let's move on to the second of the four issues, anti-competitive effects. Chris, what anti-competitive effects did the government allege?
Is that by contracting to make Google the default search engine on browsers and smartphones, Google prevents rivals from receiving the scale of search queries they need to build a quality competitor to Google. The government also alleges that the defaults discourage new competition, harm users by reducing the incentive to improve search quality and privacy, and raise prices to advertisers. Google argues the default agreements are not exclusionary because users can change the default or use a non-default search engine. Google also argues that there is competition for the contract to be the default. For example, Microsoft could pay for Bing to be the Safari default. And Google argues that scale is not a basis for imposing antitrust liability because it was lawfully acquired as the result of a superior product.
So panelists, what were your thoughts on this mix of price and non-price harms that were presented by the government?
I actually found the scale arguments to be pretty persuasive. The government's scale arguments, agreements that tie up so much of the market that potential rivals don't have even the incentive to try to make the investments that are necessary that's a pretty big effect. There was a lot of good back and forth with the judge about the foreclosure issue and 50% foreclosure on the search side, but and slightly less on the ad side. But that leaves a percentage up for grabs too. And what the judge was wrestling with is it really up for grabs, or do these agreements, even though they're not Microsoft style agreements that did not allow for any other option to be used, they're not that, but do they have so much of the market covered that effectively they're not, nobody's going to be able to get past that. They thought that they did have an option that was of the same quality in markets outside the United States. They asked Google for, and they got an exception to the defaults. And they continue to work with Google because that's their choice. Microsoft tried and made an argument to Apple that, work with us now and we promise we'll make the investments necessary to improve our product. And again, this is all being presented by Google in the closing arguments. I trust that what he was saying was accurate.
The question of foreclosure is always ultimately a question about whether competitors are capable of reaching efficient scale, right? It's by blocking competitors from reaching efficient scale that you have antitrust harm. Here I think Google has the better of the argument in a couple different ways. I mean, one, I find their competition for the contract argument pretty compelling. But two, as far as what I could glean from the parties' closing briefs, more in the briefs than at argument, really the primary evidence in the record on efficient scale seems to be from a Google expert who did what looks like a reasonably robust analysis and showed that only a very small percentage of Google's quality advantage over Bing is a result of scale. If that's right, and that's really kind of what's in the record on that point, and the government has a Daubert motion against this Google expert, and so maybe there's nothing in the record on that point, but ultimately nothing in the record isn't that much better for the government, right? It's their burden. They have to show not only that there's foreclosure, but that it means something. And I think it's tough for them on both counts here.
I do think the contract issue is one that really highlighted an area where there's contested question, whereas we might say Google is being inventive as to some aspects of market definition. I think here there's a real factual and legal question as to what allowed them to obtain these contracts and whether or not once you've done so, the maintenance of those contracts that give you the ability to be a default, whether there's a point at which that itself becomes its own type of anti-competitive problem given the nature of search. And obviously, as Dan has highlighted, there's expert evidence that suggests that may not be the case. If you competitively obtained this contract and became the default and did so based on the promise of having a superior search engine, and you in fact delivered that and continue to deliver it, not for anti-competitive reasons, but because you developed a better search engine, then obviously that's a very significant response to the government. But I think that there are real factual disputes here about that and whether in fact Google was able to improperly use in some way its contracts as a default to derive scale and to get data and to be able to keep its stronghold in search. And I think that the court's going to have to look really carefully at things like the expert evidence on scale and the role of scale, because while there may have been an initial agreement that doesn't look anti-competitive, there may be other things along the way that start to look more like foreclosure because of the nature of search and what Google was able to do with the exclusivity.
The government has argued that scale of data Google gets through the default arrangements is particularly important for mobile search, but the government has not alleged a separate market for mobile. Could that end up hurting the government here?
I mean, mobile is where Google's conduct is, in my opinion, most clearly anti-competitive. Right. It's leveraging its control over the Play Store, which obviously is a must-have for every Android phone, into default dominance in mobile search. And the fact that Google gets there by using a cute little two-step with separate contracts wasn't fooling Judge Mehta. And there's a clean remedy for it if the court ultimately decides to go there. Right? You just say that Google can't require exclusivity or any sort of preferential placement or treatment as part of any revenue share deal in Android world. I got the impression that Judge Mehta would like to go there. And the question, as Tara will surely chime in to make clear, is whether the DOJ gave him enough of a record to do it. I didn't sit through trial and I haven't studied the record, so this is rank speculation on my part, but I think the answer is probably yes. Right? Remember, the court can find a relevant antitrust market other than the ones that the parties have proposed. As we've been reminded by the Ninth Circuit's recent Epic v. Apple opinion, that finding is reviewed on a deferential clear error standard. If the dubious, bonkers, I don't know exactly how to describe it, mobile game transactions market survived that scrutiny in Epic v. Apple, surely a mobile search or even an Android search market would survive that scrutiny here. Right. So there's really just the question whether there's enough of a record to support a monopoly maintenance or attempted monopoly maintenance finding in an Android search or a mobile search market, if the court decides to go there, here's where I'm speculating that the answer is yes, but I could well be wrong.
I just wonder how hard the judge would have to work to do there. I don't disagree with you, Dan, that he certainly could go there. And if the record is there, maybe you're right. Maybe he wants to go there. My impression, and again, I didn't study the trial record. I listened to the closings and I read the briefs and I read the transcripts of the closing. My impression is that he's going to be very careful and he's not going to take chances with his findings of fact. And so if he's not comfortable that he's got competent evidence to rely on, he's not going to go there. And I do think that's one of his biggest challenges on the key issues. I put aside relevant market. I do tend to agree with you that one's an easier one for him. But on the question of the conduct and the effects, I think he's going to have a hard time.
Let's move on to the third issue, pro-competitive benefits. Under the Microsoft framework, if the government makes a prima facie showing of anti-competitive effects, the burden then shifts to Google to demonstrate pro-competitive benefits. Chris, what pro-competitive benefits did Google argue?
Google argued that the default agreements provide a better experience for users by giving them a high-quality search engine and a browser that works right out of the box. Google also argued that competition to be the default incentivizes improvements in search quality, as well as promotes competition among browsers and smartphones to offer the best integrated product. The government argued that competition for the contract among distributors doesn't address harm to search users, and that the pro-competitive benefits set out by Google were pretextual and made for litigation.
Panelists, what did you think about Google's pro-competitive benefits argument?
So the pro-competitive benefit isn't just this is something we think is good for competition generally. It has to justify the restraint. And just saying that a contract that awards the default would give us an incentive to develop and innovate in a way that any other contract wouldn't is not, you really need evidence to support that, because that's the premise that actually ties to the restraint. And I don't really think Google could show or did show that there was something about the default itself that motivated the innovation, and therefore say, well, look, in the absence of this restraint, we wouldn't have engaged in this pro-competitive behavior. And part of that is you also, and we can talk about the least restrictive alternatives and whether or not there could be contracts that would have enticed them to innovate that didn't award a default, where there might have been multiple search providers who were likewise in a contractual relationship with Apple or with Android. But I also think as a matter of proof, the evidence wasn't there that was the motivating factor for the contracts. And in my view, that kind of contemporaneous evidence is really necessary to say, this is what led us to find that there was a pro-competitive reason to engage in what has been described as a restraint. And it's often the case that there isn't contemporaneous evidence of that nature, and that leads to the argument or the response that's really pretext. You're saying it now because you're in litigation that you had some pro-competitive reason for engaging in this conduct, but there's nothing to support that. Of course, Google points to the contracts themselves and negotiations, but I didn't think there was a record to really support that the restraint itself was needed in order to get them to innovate, right? To do these things that they say they wouldn't have done in the absence of having those kind of exclusive and default arrangements.
I thought that's where the judge was too, Kalpana. I mean, the judge asked the question outright, why does Google need to pay if you're the best? Why? And you say you're innovating because you're constrained by others, but why do you need to pay if you're the best? And my ears heard more defense types of assertions coming from Google instead of justifications. And I think it was part of the strategy to really get the judge to focus on there isn't a violation, so I don't have to justify and framing it that way. But I don't think that helps them if the judge has decided that there was anti-competitive behavior.
Yeah, I agree with both Tara and Kalpana. I mean, Google's best pro-competitive effects argument, I think, is that, look, this is the kind of arrangement that our counterparties want. They want a single default search engine, and they want that single default search engine to be the one that both is the best experience for their customers and the one that makes them the most money. And so they have this competition for the contract, and we keep winning it.
Sanctions. Chris, what's the sanctions issue?
The government is seeking sanctions and argues that Google's policy to turn off chat history by default resulted in destruction of documents. The government also argues that Google instructed employees to include attorneys on non-privileged communications to prevent disclosure.
Panelists, so what do we think? Does Google end up getting sanctioned here?
I think there's a likelihood that they get sanctioned. The question is, what is the nature of the sanction? And I suspect that even if the judge is inclined to reprimand them for bad discovery conduct, that he's not going to necessarily convert it into some kind of evidentiary sanction. I think the judge wants to decide this case on the merits that are before him and is not going to want to rest on any destruction or absence of evidence to reach that result. That doesn't mean he can't come up with some other sanction to say that Google obviously should not have been deleting relevant evidence or utilizing privilege that way. But I just think at the end of the day, given the importance of the issues before him and the extensive record that he did have, he's going to want to rest his merits decision on that. So I don't see it becoming an evidentiary sanction, but he may very well take some action against Google for these discovery issues, which are significant.
I completely agree. I think Judge Meagher is going to blow Google's hair back, but I don't think he's going to rest any part of his opinion on Google's actions here.
Did you make anything of it that this was the only portion of the two-day closings that Google's lead trial attorney did not argue?
They were probably trying to signal that whatever the court does, it should not treat these issues as intertwined. And this is a discovery issue, and this is different than the underlying merits question you have before you. And perhaps having different people presented is one way of underscoring that for Google.
Okay, time for predictions. How do we think this case gets decided? And if you say in favor of the government, what does that remedy look like? And I'll go first here, just to get things started. Dan, I actually agree with you. I think one of the remedies is going to be no more pre-installation of Google apps on Android. You're going to not see those on OEM phones that run Android. I think it's a nice, clean, structural remedy. All right. What do the rest of you think?
I think it's likely that the judge will agree with the government on the relevant markets. I do think that he's struggling with the conduct and effects, and I predict that he's going to find that DOJ failed in its burden to show that there is exclusion here, and he will also run through the effects to make it clear that there's a failure of evidence there as well.
I follow Anant's and Dan's view that the court is going to do something to decouple the link between Google and mobile, so some form of structural injunctive relief to prevent it from being a default on there. I also wonder whether he will take on the issue of the ease of being able to change default search engines. I think that is a very consumer-facing issue where some form of structural relief could be ordered by the court, and there may be a way that he thinks about that might be another form of relief. But given the evidence that was presented and the issues around the contract and what types of justifications were not presented, that seems an area that's really ripe for the court to take action.
I'll stick with my position at the outset that the government will win on Android and lose on everything else, and that there will be injunctive relief targeted as Anant suggested.
Did anything come up in closing arguments that you think we might see again in FTC v. Amazon or the Google ad tech case or DOJ v. Apple? And the reason this question came to mind for me is that I found that Judge Meagher really struggling with quality harms. And I saw this in the DOJ v. Apple, where they're arguing that there is a version of a smartphone that is better than what consumers are getting now. Just like one of the issues here is that there's a version of search that is better than what consumers are getting now. It just struck me as a hard thing for judges to grapple with. And I'm wondering whether any other panelists had thoughts on that.
It's a really hard thing for judges to grapple with if you're not giving them economic evidence to ground it in, right? I mean, here's a place where I'll back Tara full-throatedly. If you want to make a claim that quality adjusted price has shifted one direction or another, you need to have some econometrics to back that up.
We'd like to end these with some key takeaways for practitioners, and I'd like to have our panelists each offer a takeaway from the closing arguments. Kalpana, why don't we start with you?
The importance of your evidentiary record, I think, was really underscored here. There are certainly going to be some novel questions on the law and its reach, but I think in this case, they are really driven by the factual landscape here, and in places where either side seemed to be struggling with presenting a form of proof, it was something that the judge was focused on very carefully. And it's not going to be enough to have positions or arguments on that if you don't have evidentiary support, particularly if you have a fact finder that's as detailed as Judge Meagher is.
I was going to offer a similar takeaway and really focused on the government. It is their burden to prove these elements. And what we heard many times, not just once, not just twice, not just three times, but we heard the DOJ lawyer saying to Judge Meagher, that's not my burden. I don't have to do that. It's just a huge mistake. And for those of you who predicted that the government's going to come out on top here, I think if there's a reason, one of the biggest reasons if they don't is because the judge is just going to make findings of fact based on what he's got, and he's going to fault the government for not putting on more evidence, economic evidence, better analysis, and kind of short shrifting the judge in a case that is so monumental that requires detailed findings of fact along the lines of what we saw in Microsoft.
All right, I won't beat the evidence horse. Key takeaway, primacy of market definition, right? Those are fights that never get old, and certainly in markets that are evolving as quickly as all of the high-profile markets on the dance card are, your best evidence.
Well, thank you, Chris, for being such an excellent co-host, and to Tara, Kalpana, and Dan for your insights into the closing arguments of what may or may not be the antitrust trial of the century. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.